According to the Ugandan National Employment Policy 2011, domestic workers are among the most vulnerable and marginalized workers. Domestic workers are exposed to conditions of abuse and exploitation due to failure to regulate recruitment and employment process. The poor legal framework results in limited access to justice by domestic workers whose rights are abused and violated in the workplaces. In 2017, Platform for Labor Action conducted a study. 93% of domestic workers are female, and 65% are youths, primarily from rural areas. The invisible and hidden nature of domestic work makes the domestic workers prone to abuses and marginalization. Therefore, the inappropriate legal framework forms the basis on which government has been expeditiously called upon to consider regulating domestic work, study the status of domestic workers, and the critical need for domestic work legal regulation, societal stereotypes, and promotion of decent work in the sector. Ministry of Gender, Labour and Social Development, MGLSD, sought out support from PLA to develop regulations for the domestic work sector, and it will be an opportunity for the workers' voices to be incorporated into the development process of a law that directly impacts on their economic achievement and protection. PLA, in partnership with Ministry of Gender, Labour and Social Development, with funding from Urgent Action Fund, has held consultative meetings with domestic workers, employers of domestic workers, recruiters of domestic workers, local council leaders, national stakeholders, labour union representatives, Federation of Uganda Employers, different government ministries, and civil society organizations. All these working to promote, protect the rights of vulnerable workers and provision of legal protection for domestic workers in Uganda. Key highlights and highly contested provisions in the meetings were abolition and prohibition of child domestic workers. At the national consultation meeting that took place on 15th December 2020, leaders of domestic workers argued that in the paid domestic work sector, there is no light work as envisioned under Section 32 of the Employment Act 2006, which states, "A child under the age of 14 years shall not be employed in any business, undertaking, or workplace except for light work carried out under supervision of an adult aged over 18 years, and which does not affect the child's education." It was argued that child domestic workers face the worst abuse at workplaces, including physical assault, non-payment of their wages, compiled with overexploitation. Ms. Atieno Florence, the General Secretary of Domestic Workers Association, shared that children employed as domestic workers are always beaten by their employers because of not concentrating and/or finishing their work in time or in a satisfactory manner required by the employers. They are cheated by their employers, with sometimes only receiving payment in kind, such as clothes, while others do not even get their wages at all. Children lack a voice because they are children, and the fact be told, domestic work is manual work. It is not light work. Miss Victoria, a domestic worker from Machindye, shared that, "We work in closed gates. Some domestic workers are not even allowed to get out of their employer's premises. Therefore, once a child is employed as a domestic worker, they cannot get time to continue their education. It is not practicable in the domestic work sector because time for school, he or she is supposed to be at work." Mandatory medical checkup for domestic workers before placement. The proposed diseases to be checked include HIV, malaria, pregnancy test, hepatitis B, meningitis, COVID-19, and any other disease. This proposal sparked a protracted discussion among the stakeholders. A section called for the deletion of the proposed regulation, with the argument that the regulation, if passed into law, will promote discrimination of persons on the basis of their HIV status, which has since been outlawed. Ms. Hanifa Katwesige, the chairperson of the Domestic Workers Association, shared that some employers force their domestic workers to test, particularly HIV, to ascertain their status to inform their decisions of whether to sexually harass the domestic workers or deny the prospective domestic worker employment. With regards to pregnancy, Ms. Maria Lamunu, the national coordinator from Uganda Women Parliamentary Association, categorically stated that pregnancy is not a disease for the regulation to categorize it as part of the medical checkup that should be undertaken before one is placed for work. It is a maternity right of every adult female Ugandan guaranteed under the Constitution of the Republic of Uganda and reinforced in the Employment Act 2006, under which these current regulations are being drafted. This will also be exploited by the employers to discrimination domestic workers found to be pregnant. Pregnancy is also not contagious to anyone. The costs for the proposed medical checkup was another issue. Ms. Maureen Mulika from Milestone Domestic Services stated that testing domestic workers is not a problem. However, most of the domestic workers that we recruit are from poor backgrounds, and often they do not even have money to transport themselves to the places of work. If the regulations do not clearly spell out who to bear this cost, the employers may require the domestic workers to pay for their checkup, or even an employer may pay but later deduct the said cost from the domestic workers' meager wages. Provision of paid 60 working days maternity leave to domestic workers. The consultation process highlighted the difficulty in implementation and enforcement of the proposed provision on maternity leave for domestic workers, while some of the stakeholders argued that this is a constitutional right under Article 40(4). The domestic workers shared their insights about the provision. Ms. Rehema Chisingo, the Treasurer Domestic Workers Association, shared that, in practice, when a domestic worker gives birth, she is asked to look for a replacement to cover for her during the maternity leave period of about 21 days. During this period, the domestic worker does not receive a salary, but she is only assured of retaining her job when she returns. This practice, however, contravenes the current provisions of Section 56 of the Employment Act 2006. At the end of the meeting, there was no agreed-upon drafting language on this provision. Village local council chairpersons to be part of the redress structures in labor disputes for domestic workers and employers. All stakeholders welcomed the proposed regulation because the LC1 chairpersons are the first point of entry into the justice system and a redress structure. Mr. Charles Sechiranda, LC1 chairperson from Bwaise Zone, stated, in practice, domestic workers' issues are always reported and handled by the local council leaders because we are the quick point of access for any community members. What I would recommend is that the regulations need to be very clear as to the powers of the local council leaders when it comes to domestic workers' disputes of a civil nature. In addition, I would also recommend that the local council leader should handle the matter within 7 days only and refer the matter immediately if parties do not settle the matter. Developed by PLA with support from UAF-U.